At Raju Law, we don't just provide legal services, we provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving your time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello, good morning, everyone, to our regular show, Monday Live for Immigration for All. But many of you already know that we started a new season, a special shows on get access to U.S. market. So in this season, we are going to help foreign entrepreneurs invest in America. And through that investment, if you like to get immigration benefit, you're most welcome. But if you do not want to get immigration benefit, that's okay too. A lot of foreign entrepreneurs, they just want to invest in America. They don't want to move here. That's totally fine. So when you invest in America, not only you start a business, you may or may not immigrate. On the top of that, there is many other things you need to be aware of. And one of those things is estate planning. Many foreign entrepreneurs has no idea about this topic. So to talk about estate planning and how a foreign entrepreneur, foreign investor may need help with estate planning. So we have a very special guest today, my good friend Scott Switzer. He is an attorney admitted to practice in Washington, D.C., Maryland, and Virginia. Also, he has a lot of business clients in New York and Florida. The name of his organization is Prime Estate Planning. You'll definitely get those information on the screen. So without further delay, let's welcome Scott in this show. Scott, good morning. How are you?
I'm doing very well, Roger. Thank you very much for having me here. Happy to be here.
Thank you so much for joining. And so, without further delay, and also I should remind our audience today that this is not a legal advice. This is an information purpose only video for our audiences. We will, talk roughly about estate planning for foreign entrepreneurs. So if you have any special question, if you need one-on-one meeting, I would highly recommend you to take appointment from Scott. You'll get information how to take appointment from him and talk to him. But today is just a surface level information purpose only. Scott, without further delay, please tell us the very basic things, what estate planning is, and foreign entrepreneurs, especially medium and small size entrepreneurs, how they can get benefit from this.
Okay. Well, first of all, estate planning pertains to anyone who is going to die. So we're all going to die at some point in time. And we all might become incapacitated at some point in time. We might get sick. We might end up in the hospital. And incapacity planning is part of estate planning as well. And what I will say, my experience has been that in many countries, you don't have to make a lot of choices about estate planning. The state makes those choices for you, or you perhaps have a will and you go through court, and that's basically it, for better or for worse. But as in many things, the US is the land of choices. And so what that means is that if you do nothing, you're most likely to end up, or your family will, with a very bad outcome, losing a lot of money, spending a lot of time in what's called probate court. So it's really important to get educated on what your different options are and make sure that you're investing in the right professionals and making the right choices. And just as a quick example, if you do nothing in the US, the US law will dictate who gets what and so forth, and your assets will go through a process called probate court that will take anywhere from 1 to 2 years. They'll be frozen, your family can't access them, and it's there for the purpose of your creditors taking those assets first before your family gets them. So that's probably the worst outcome. So what you want to do is make sure you have a plan in place, educate yourself and realize that here in the US, it's a different system. You're just going to have to get used to it. It'll take you a while, but it'll be worthwhile in the end.
Perfect. Thank you so much for reminding that. And we all will die. A lot of time people don't realize. A lot of
Yeah.
people, we are very healthy. We are very active, and especially entrepreneurs. They're very active. Very many of them are healthy, and they said, "Oh, they even don't think about dying." But this is part of life, so we should all be careful about this thing. So when a foreign entrepreneur invest in America, of course they have choice to register business in any of these US 50 states. So
Yep.
does it matter, like in terms of estate planning, which state or states are better and which state or states are not good? I know that you're admitted to practice in Maryland, Washington, D.C., and
Yes.
Virginia,
Yeah,
but
yeah,
from your
yeah.
general idea, like which states are better?
For estate planning purposes, it really doesn't matter where you actually register your business. I think you had a previous lecture on here who talked about tax planning and creditor protection and things like that, and there are better places for that. When you get to the more complex side of estate planning and you're creating certain types of trusts, asset protection and things like that, there are states that are better for those purposes. But that comes later. That comes after you have 10, 20, 50 million dollars in net worth. We can talk about those type of things. But when you're establishing your business, you really don't have to worry about estate taxes too much in terms of the venue.
Okay, perfect. And in terms of registration, does it matter like it's a LLC or corporation, like a single member, multi-member? Does it matter?
Well, it doesn't matter too much, but here's what I'll say. So, if you do nothing, it's sort of like no estate planning. It's sort of like a lot of countries have a public healthcare system and then private healthcare systems. You pay more into the private ones, but it's usually better service and so forth. So, in the U.S., you can think of probate court as the public system. You get worse service, but it ends up costing your estate or your family a lot more money. So you don't want that. So the typical document that everyone knows about for estate planning is a will. A will in the US goes through probate court. So one of your first goals, once you have some assets in the US, like a business, a residence, etc., is to avoid that public system, avoid probate court. And you do that by creating what's called a revocable living trust. Okay, so that's the first primary entity, and you don't want to do that by yourself. You want to hire somebody who's really educated in those types of things. There's a lot of choices to be made. One of the things you need to do when you get the trust is you need to have your attorney or work with them to create an inventory of all of your assets, including your businesses, the value of them, how they're titled, how they're owned. And when it comes to businesses, whether it's an LLC or a corporation, there are techniques to get the business inside of the trust so that when you die or become incapacitated, the business does not go in probate court and get frozen, because then the business will fail. So you need to make sure that the business is owned or inside of the trust to protect it from incapacity, death, and so forth.
Yeah. And so since you mentioned about wills and also mentioned about trust, a lot of time people have idea that probably will or trust or will or estate planning. Can you please explain how like all three are interconnected and entrepreneurs, they should take care of all three: will, trust, and estate planning. How do they do it, like all three together?
Yeah. Well, what I would say is that, when I see clients and so forth, we have an inquiry and everything else. We probably have 20 documents. It's insane. But the big 5 documents that you'll need would be a will. And the will basically says after you pass away, who gets your assets and so forth. In my plans, the will is a backup. It's a backup item if you don't get the right assets to the trust. So you have a will, then you have your revocable living trusts, and that's kind of like a shopping cart. If you imagine yourself going to the grocery store, you're picking up milk and eggs and things, and then you have a heart attack. Everything falls on the floor. It's a huge mess, right? That's what probate court is. They have to come in and sweep up the mess. But if you have a shopping cart and you're putting things in the shopping cart and you've already chosen people who will take over, if something happens to you, well, the next person just takes over and they keep moving the cart along. So that's what the trust does for you, basically. So that's the will, that's the trust. And then you have a few incapacity documents. So a power of attorney for financials, a medical power of attorney, and there's a document called a living will as well. Basically what we're doing there is you're planning for incapacity. You get sick, you get into an accident. You might imagine if that would happen, your family could just come in and take care of your affairs. No. If you have not chosen that, they have to, along with anyone else, go to probate court and go through a court process to get appointed to control your affairs, which can take weeks or months, and often the wrong person is appointed. So it's really important to get those incapacity documents in place as well.
Perfect. Yeah, that is very important about, especially like a medical matters and other things.
Oh
It's
yeah,
really important.
exactly.
Yeah.
Yeah.
Also, so as I said initially, like some people, they may invest in America, they may have property, assets, but they do not live here in America.
Right.
Also, some people, they may move here and stay here. So what is the difference? And for both scenario, can you please explain like what they should be careful about?
Sure, sure. So let's say example for you, you immigrate here, and very quickly you get your green card, and you're considered to be a resident. In the estate planning world, the term is domiciled. You are domiciled in the U.S. in a particular state. I won't go into the definition because it has like 50 different components. It's confusing, but you're basically here. Then you're treated like a U.S. citizen for estate tax purposes. And so what you want to focus on there is you want to make sure you have those 5 documents. You want to make sure you have your revocable living trust. You want to make sure that it's totally funded, meaning that the assets are in the trust, retitled in the trust, or if you have assets that have beneficiary designations like life insurance or retirement accounts, that they're pointed towards the trust. And you'll work with an estate planning attorney to get that done. And then you want to make sure you're working with somebody where you're meeting with them at least once every 3 years. I have a membership program, so clients meet with me every single year to see if their business has changed, their assets, their family dynamics, if they have kids. You want to have a relationship with that person like you do with your CPA, your financial advisor, whoever it is that's part of your life on a regular basis. That's really important. So that's basically for people who have immigrated to the US and so forth, and they're here. What's interesting to know is that if you are not a US citizen, you're not a US resident, but you're simply buying assets in the US, you got a problem, actually. There's this thing called estate tax in the US. And what that means on the federal level, so all US states, if you have a net worth above a certain dollar amount, and right now it's $15 million per person or $30 million per couple in a relationship, anything below that is not taxed. Anything above that is taxed at 40%. So some of you may never get to $30 million or $15 million. If you do, you need to work with your estate planning attorney to deal with that, to mitigate those taxes, okay? But if you're not a U.S. citizen, if you're not a U.S. resident, so let's say you live in Europe or Asia and you just buy property here, the U.S. law is very different. Your exclusion is $60,000. So any asset or net worth over $60,000 will be taxed, taken by the U.S. government 40%. So let's imagine you buy a house here for $1 million. Let's imagine when you die, it's worth $1.5 million. 40% of that will be lost. Same thing with your business assets, anything else. So that's a terrible investment. Would anybody buy anything knowing that when they die, 40% of it will go to the government? I don't think so. And a lot of people are really not aware of that. So, there are ways to deal with that. For example, you can buy you can purchase assets in a foreign corporation, and then through an LLC, there are techniques to avoid that estate tax situation. It's complicated. It's changing all the time. But if you're going to be investing in assets in the U.S. and you don't think you're going to be, moving here and becoming an immigrant, it's very difficult to almost impossible to put those assets into those vehicles after you buy them. So you need to do that homework beforehand. And it's just super important. You know what I mean? I have a lot of clients that come in and say, hey, I've got $1 million house here in Washington, D.C. I live in Panama. I never come here, blah, blah, blah. What should we do? My advice is to sell the property as soon as you can, because we don't know when we're going to die, right? Something could happen. And you don't want this huge catastrophic loss to your net worth and everything. And for the entrepreneurs out there, I know if you're young and you're fit, and I'm an entrepreneur, we're not thinking about, legacy planning, death. We assume that death is way off in the distance. But, I have clients die in their 30s and their 40s and so forth. So this is just part of planning that you really have to do.
Perfect. And we'll talk more about this. We'll just take a quick break. Especially after this break, we'd like to know, like, if the property is under like a LLC instead of like under a personal name, what is the impact of that for estate planning tax? But before that, we'd like to take a quick break.
All
Please
right.
stay with us.
At Raju Law, we are proud to offer one of our most promising services, the EB2 NIW application. With an incredible success rate of 94%, our team has helped more than 1,000 clients navigate this efficient route to permanent residency in the United States. EB2 NIW allows highly skilled professionals and individuals with exceptional abilities to apply for a green card without the need to find an employer sponsor. Whether you're a scientist, engineer, doctor, or entrepreneur, this visa offers a unique opportunity to live and work in the United States based on your qualifications and contributions. At Raju Law, we're here to guide you every step of the way, making the process seamless and stress-free. Contact Raju Law today for the free EB2 NIW evaluation and start your journey.
Welcome back after our short break. So as
Thank
we are
you.
discussing about property ownership here in America without living here,
Yes.
and Scott said immediately his advice would be immediately sell it. So Scott, so my question is, what is the difference between property ownership in terms of estate planning, of course, property ownership under someone's name or someone under a LLC, and how estate planning tax applies there?
So if you're not going to live here and so forth, and you're not married to somebody who does, you're never going to want to buy property under your own personal name unless you know you're going to sell it very, very quick and you're willing to risk you're not going to die during that period, right? Because there's that 40% estate tax and everything. An LLC is commonly used to own rental property, for example. It's a business entity and it's very appropriate, in that situation, and it has a lot of benefits. But specifically for people who are not going to live here, you're going to want the U.S. government to treat that property as foreign property, so that it's not, that it's actually located someplace else. So in order to do that, you have to use a combination of foreign corporations that then flow through to an LLC. There has to be 3 layers: you, the LLC, the foreign corporation. And for people who have questions about that, I can, it's very, very complex. So I can go into more details one-on-one and so forth. So it's not an easy situation. Now, if you have an LLC or a corporation that owns real estate or a business, you can also get that inside of your revocable living trust for normal estate, for normal probate protection and so forth. That's easy to do. But yeah, if you're dealing with somebody who's not living here and doesn't have a spouse that's here, there's going to be multiple layers. Because the U.S. wants their money.
Yeah, exactly. So this is please go ahead.
No, that's it. Go ahead. That's good.
Yeah. So this is the thing. U.S. wants money, and so that is good and bad in both ways, because because U.S. wants money, they made a lot of laws so that people can invest. They can money from foreign country to America, but at the same time, you have to be careful because they want money from tax too. So you have to make your plan in a right way so that you pay less tax. Of course, you cannot avoid any tax at all, but you can pay less tax things. So another thing, Scott, you just mentioned about like a spouse do not live here. So what is the situation? Let's say one spouse is a U.S. citizen, another spouse is not. So what is the situation for estate planning for that situation?
It's basically half. It's much better than it is when there's no U.S. citizens. So that one spouse will get they'll get their estate tax exemption, so $15 million. One thing to note as well is that a lot of individual states in the U.S., Maryland, with Oregon, Washington, New York, etc., they have their own local estate tax laws, and the threshold is usually lower. So when you actually go ahead and figure out where you're going to live in the U.S., you're going to have to work with an attorney to figure out how to plan for those. For example, in Washington, D.C., the threshold is $4.8 million individually or for a couple. So if you have a business and you have real estate and so forth and life insurance proceeds, you could easily hit that level without knowing about it. So when it's a situation where you have one U.S. citizen and let's say someone who's, doesn't even live here, you have to create a special type of trust called a QDOT, a Qualified Domestic Asset Trust. And what that does is basically when one of the parties dies, the proceeds go into this trust that's managed by a trustee who is based in the U.S. And that way the U.S. won't go ahead and take those estate taxes away. So it's a special structure. It's fairly complicated to put in place, but we do it all the time. And it's important if you have one spouse that's in the U.S. and one spouse that is not. Now, it's not that important if your net worth is, lower than that, but it's still something that if you have a business that's growing and so forth, that should be your default setup.
Awesome. Thank you. So for audience, my friend Scott's information is showing on the scroll. His phone number, email address, everything is there. Feel free to reach out to him. But Scott, how people can reach out to you? How people can find you in social media or any other place? Please tell them.
So if you Google Prime Estate Planning, my firm will pop up. I'll put in the chat here. Let's see, I'm not sure if I can. Let's connect to YouTube. But I think I gave you the email and so forth. So there's basically an email address for us. There's a QR code for you would then call in, and my client service director, Safi, takes all calls, sets up. Yeah, you can scan that QR code right there and you can schedule. You can schedule a call and everything else. So that's a perfect way to do it. And yeah, we're here to help you. And even if you plan on living in a different state, I'm part of a community of estate planning practitioners in almost every state. So even if we can't help you directly, we can connect you to one of our trusted colleagues who can.
Perfect. All right. So we will go back to questioning again. Scott, thank you very much for providing all the information about how to reach out to you. So let's say a foreign citizen living in, so he's a Portuguese citizen or Italian or like a UAE citizen, has business here, and let's say he or she did estate planning. Which countries they recognize American estate planning documents, and is there any treaty countries? How does it work for foreign nationals?
That's actually a very complex subject. So it really depends on the specific of the tax treaty that we have and everything else. There are some countries, for example, where you can create a U.S. trust and they will recognize that, and you can put the foreign assets in the U.S. trust, and that's totally fine. The majority of countries will not, or they will tax them very heavily. They treat them like businesses. So in that case, often what you'll do is you have separate estate planning in both places. You'll work with someone like me for the U.S. You'll introduce me to your estate planner in Dubai or wherever, and we're going to have a conversation of how to create separate plans that are consistent with each other to deal with assets in the foreign country and in the U.S. to make sure that they don't conflict. And that's one of the challenges. I wish there was an international estate planning, consistency and so forth. But what it means really is that you really just want to have two people that work together and understanding of how those tax treaties work.
Perfect. And there are some situations where gift tax is applicable for estate planning. How does it work, and in what situation they should be careful about?
So gift tax, basically the idea is that the U.S. government wants to get their taxes. So if you're giving large gifts, and usually I think the exclusion right now is around $19,000. So you can give $19,000 to as many people as you want per year and have no gift tax implications. So a lot of families will do that. Grandparents who are well-to-do, parents will just gift every year in that amount, and it doesn't cause any ramifications. If you gift more than that, you are required by law to file a federal gift tax return. And what that does is it counts against your estate tax exclusion. So if you gave away $10 million, you'd only have $5 million of that $15 million left. So really what you do in that situation is there are certain techniques you can use to expand the gift tax. These are all advanced tax strategy. Or there are certain types of vehicles, certain types of investments and strategies that you can use. You can transfer assets into those. You could put money or an investment into an irrevocable trust. It gives you back an annuity with money that you pay income taxes on, but then you get that money out of your estate for estate tax purposes. And let's say, for example, that your income tax is at 25%, you can use the money, and the estate tax is at 40%. It makes sense to pay the 25% income tax to avoid the 40% later on. And that's how many of the very wealthy people can get tens or hundreds of millions of dollars out of their taxable estate without touching gift tax.
Yeah. And I just want to make sure that our audience understands this. This 40% tax or any tax that we're talking about is after you die. The entire estate planning thing happens after you die.
Yes.
You're not going to pay this tax every year. This is not your regular business tax or personal tax.
Yeah. Don't get too scared about that. It's after you pass away. Yeah.
Yeah,
Exactly.
yeah, after you pass away, exactly. So another question. So let's say a foreign person moved to America with a green card or become a U.S. citizen, has a lot of properties and assets here in America, did estate planning, but he or she has some properties or assets left in his previous country.
Right.
Can he include those in the estate planning here in America?
Yes, you can. And you're actually the U.S. wants you, the IRS wants you to include that so they can figure out whether they want to tax them or not. You know, but you can't necessarily just move them into your U.S. trust because that may run afoul of the laws in separate country, and that's why we need two attorneys, one from each country. Um, I have a lot of clients who own family property, farms, second homes in different countries around the world. And sometimes they choose not to tell me what they own. And so it's not even listed with the US. And, that's illegal, but it's maybe a low risk strategy. So some people may choose to do that. When you have a problem is if you have companies that are easy for the IRS to find that generate money, or if you have rental properties that are producing income, then it's pretty easy for the IRS to find out that actually you have these other assets, and then they're going to sweep in and add those to your estate. So you just have to be very kind of careful in which particular type of asset you're dealing with.
Exactly. And another thing, so let me give you like a scenario. So Mr. X from a foreign country, he's like an older gentleman. He has like a house and rental properties here in America, and he did not have estate planning. He passed away. Now his children, they live in foreign country and they don't have U.S. visa to come
Right.
here to go to court. They reach out to you to represent you. Is it very easy to represent a foreign national who doesn't have visa in a U.S. probate court, or it's difficult?
What we would have to do is we would most likely in that situation, if there's no estate planning, we would have to go to the court and ask the judge to appoint a personal representative. So they would appoint
Mhm.
some attorney who doesn't know your family, and that personal representative would take those assets through the process, have creditors pay for them and so forth and everything else, and eventually then they would go ahead and distribute them. The weird thing is if they're in the U.S., they're going to distribute them according to U.S. law. So it may have nothing to do with the wishes of the gentleman who passed away. So it may go to his ex-wife. It may go to his kids who he has no longer, any connection with, his cousins. It would just go according to U.S. law with no consideration to what he actually wanted. So at the very least, we want him to create a will, so that and probably a revocable living trust to make sure that his wishes are respected.
Okay, okay. Yeah, just to make sure that in this situation they need to appoint a representative, and you being an attorney, they're still at a probate attorney. Can you be the representative and attorney at the same time, or you cannot?
Typically not. You'd find someone else. I mean, I have some foreign clients who they have a friend or a business acquaintance, somebody that they trust in the U.S. that they get paid to go through that process. They're not the attorney, so that's usually better than letting the court pick somebody who's a total stranger.
Okay, yeah, okay. All right, and how to avoid this kind of litigation?
Well, I mean, avoid this kind of litigation just by getting educated beforehand. Work with an attorney who's knowledgeable with these kind of things, and try to keep in the U.S., try to keep your estate out of court as much as possible. You know what I mean? Because the U.S. is more litigious than a lot of countries. We have a lot of good things going on, but there's a lot of lawsuits in conflict, just the way that we're set up. You know what I mean? So some things I want to talk about really quickly is that basically, in the U.S., I have this conversation with real estate investors or business owners a lot, because they want asset protection. They want to make sure that they don't lose their business or assets to lawsuits, creditors, bankruptcy, things like that. You know what I mean? So basically what you can do is you can do things like buy what's called an umbrella insurance policy. You can buy insurance that provides a large cap over yourself so that something bad happens, like a lawsuit to your family or something goes, in your business, that will pay out up to a certain amount. That's usually the least expensive and best way to start getting protection from some of that litigation. The next thing would be if you have businesses, make sure that they're owned by the right type of entity, be it an LLC, a corporation, perhaps limited partnership, and so forth. And make sure you're working with a business attorney who sets up the documents correctly and make sure that you're actually following the rules so they're not getting overturned in court. You're going to want to work with a CPA or an accountant in the U.S. as well who knows those rules, who can make sure that you're doing everything professionally and correctly. Those are sort of the Those are the building blocks, actually. As you get wealthier, people may have companies in LLCs and they develop a holding corporation, a bigger business on top of it that actually manages the smaller ones. And that's a way of protecting assets and protecting litigation as well. And then finally, these are for my well-to-do clients who are in risky businesses like real estate development, places where there are a lot of big lawsuits. There are things called asset protection trusts. They're irrevocable trusts. They can be domestic, meaning that they're in the U.S., or they can be hybrid, meaning that partially in the U.S., partially there's someone else somewhere else, like the Cook Islands, that have very favorable laws. They're expensive and they take a lot of work to administer. But if you're really at risk of losing a lot of your money, for example, I have a client who's a developer worth about $50 million. They signed a $10 million note with a bank to create a hotel. And then the pandemic hit. And of course, they realized that no one was there. So they did not want to lose $10 million. So we created a trust. We moved it offshore so they did not have to pay the $10 million back to that bank. So that's an example of a situation where that high level of asset protection is probably is worthwhile. One thing I'll say is that once there's a lawsuit against you, it's too late to shield your assets. You've got to think ahead and realize that you're in a high risk situation and do planning beforehand.
Yes, that's very important to know. Like once you get the lawsuit, you can still do planning, but but it's already too late. So I highly recommend everybody to start thinking about planning immediately so that they can start protecting their property and assets. Yeah. So we are almost end of this session. Before I go for your concluding remarks and anything we left over, is there any minimum amount of assets that required to take service from your organization, or is there any list of the countries that you will probably avoid not touching anything from your end?
I don't have any countries that I run into that would avoid. Places that U.S. Like maybe Russia and North Korea and Iran, and that might be a problem for me, but it hasn't bumped into me yet. I'll still take the call. I'll figure it out. You know what I mean? But back to your first question, I would be upfront that our fees typically range from about $3,000 to about $9,000 US. You pick your fee in there. It's a flat fee. So first of all, you have to be able to afford that. You know what I mean? That's, if you can't afford that right now, that's fine. And I would say that, the planning that we would do, I would say that you at least want maybe $500,000 US. You want to have an asset like a home or a business that would go through probate court. And you have to care about what happens after you die. If you don't care, then, what are you doing it for?
Yeah, thank you very much. So our very last question, your closing remarks or anything that we did not address today that a foreign entrepreneur should know before investing in America?
Well, I just think it's important from a business perspective and so forth to really kind of diversify your risk, to kind of know what your target audience is going to be and so forth, and know where you're going to make your money, and really understand tax law, how you're setting things up and how you're going to be taxed, and make sure it's done in the most tax efficient way. You know what I mean? And get your people together, get your team together. That includes your CPA, your tax attorney, your estate planning attorney. I'm sure I'm missing some people here, business coaches and things like that. If you're starting out with not a lot of money, you can hit the ground running and so forth. But I would say if you're not planning on actually immigrating here first, and you do have money or to start a business, don't skip the step of creating the right structure to make sure that that you're going to be protected from that kind of estate tax, because it's a really costly mistake.
Exactly. Well, before we conclude, so there's 2 comments from our audiences. None of those are related to estate planning or anything. That's why I did not address those. But let me address their general question. So Saif Ivan, he asked me, how are you? And he asked in a foreign language. Yes, I'm good. Thank you very much for watching our show today. And Mr. Masood Mia, he asked, how can easy way for EB3 visa? So Mr. Mia, today is not topic for EB3. We will have another session another day. That time I'll ask our guest to talk about EB3, but today our topic was estate planning. So Scott, thank you very much for joining today. I really am grateful to you, especially this holiday period. You're joining, you're giving us time. You have a wonderful day. And if you have any last comment to our audiences.
No, I just want to thank you very much, and I want to thank the audience. And feel free to contact us, and then share my information with anyone else in your community, in your network, who needs to hear this message. And we're here to serve.
Yeah, thank you very much. Have a wonderful day. And audience, please come back next Monday at same time, 11 a.m. Eastern Time. We'll talk about a different topic. You all have a wonderful day.
Take care.
Bye.
Hi everyone. Welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include USCIS increases screening, vetting of aliens working in US. USCIS updates policy on biometrics for detainees. USCIS establishes new vetting center. Expanded screening for H-1B and H-4 visa applicants. US widens travel ban to more than 30 countries. Let's start with new rules for work authorization. USCIS has reduced the validity period for certain employment authorization documents from 5 years to 18 months for refugees, asylum grantees, and applicants with pending status adjustments. Parolees and TPS beneficiaries will have EADs valid for 1 year or until the end of their status. These changes take effect for applications filed on or after December 5, 2025. Next, updates on biometrics for detained individuals. USCIS clarified that detained individuals will generally not provide biometrics unless in removal proceedings with a pending application before the Executive Office for Immigration Review. Applicants who fail to attend biometrics appointments may have their immigration benefits denied. This policy is effective immediately for pending or new requests. Now, a major national security initiative. USCIS opened a new vetting center in Atlanta to strengthen screening of applicants and identify terrorists, criminal aliens, and other public safety threats. The center uses advanced technologies, including AI, and coordinates with DHS and law enforcement to review pending and approved applications more thoroughly. Next, expanded online presence reviews for visa applicants. Starting December 15, DHS will include all H-1B and H-4 visa applicants in online presence reviews, alongside F, M, and J visa holders. Applicants must adjust social media privacy settings to allow this vetting, ensuring eligibility and national security compliance. Finally, the latest on US travel restrictions. Secretary Nom confirmed that the US plans to expand its travel ban to over 30 countries, targeting nations with unstable governments or inadequate vetting processes. This expansion responds to a recent shooting by an Afghan national and is part of broader efforts to tighten immigration and limit resettlement from high-risk countries. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest US immigration developments.